Welcome to the Employment Law Update. We'll be covering the employment law developments since October 2020, including updates made to legislation since October, planned changes to legislation that have not yet been implemented, and recent case law that you should be aware of. The first piece of legislation that you need to be aware of is the change to the off-payroll working rules in the private sector, or otherwise known as IR35, and these are going to be introduced from the 6th of April 2021. As some of you may be aware, this change was set to be introduced last April, but was postponed due to the coronavirus pandemic. The changes apply to services provided by an individual through an intermediary. One example of an intermediary is a personal services company. Where the nature of the relationship for tax purposes is akin to employment, then IR35 will apply to the relationship. In making this determination, an assessment of the relationship as a whole and a number of other factors will need to be taken into account, and it doesn't just take account of what the contract states the relationship is. The end client or the hirer will need to make a status determination as to whether the relationship with the individual falls inside or outside of IR35. The hirer will also be responsible for resolving any disputes with the individual about the status determination that has been made. Where IR35 is deemed to apply to the relationship, the responsibility for the payment of tax and national insurance contributions for that individual shifts from the intermediary to the fee payer. This is often the end client or the hirer, but not always. PNEP calculations are another change that you should be aware of. So PNEP, or post-employment notice pay calculations, have previously been counterintuitive for employees whose contractual notice period is expressed in weeks but is paid monthly. HMRC have resolved this previously to allow employers to use an average number of days, usually set at the value of 30.42 in a month, for the value of P, rather than the actual number of days in the last pay period. From the 6th of April 2021, legislation is being updated to include this alternative methodology. In addition to the changes previously discussed, there are also going to be increases to the statutory rates of pay from the 4th of April 2021. Statutory sick pay, or SSP, will be increasing to £96.35 a week, and statutory maternity, paternity, shared parental leave pay, and adoption pay will increase to £151.97 a week. Despite some speculation that there wouldn't be an increase to national minimum wage due to the impacts of the coronavirus pandemic, particularly coming from the retail sector, national minimum wage rates will be increasing from the 1st of April 2021. Please note the increase to the national living wage, which previously only applied to workers aged over the age of 25. This now applies to workers aged 23 and over, and has increased from £8.72 to £8.91. Minimum wage for 16 to 17-year-olds will also go up to £4.62. The accommodation offset allowance for the purposes of calculating national minimum wage compliance will also increase to £8.36 per week. Another change that has been made is the gender pay gap reporting. The deadline to publish pay gap reports last year, which was the 5th of April 2020, was paused due to the impact of the coronavirus pandemic. A revised deadline for private sector organisations to publish their reports has been set for the 5th of October 2021, and this includes reports that were due by the 5th of April last year. When deciding if reporting duties are triggered, you'll need to take into account workers who have been furloughed under the Coronavirus Job Retention Scheme. You will also need to consider such workers for the purposes of calculating the gender bonus gap, excluding those, however, who have received less than their full pay as a result of being on furlough. In reality, this is likely to exclude furloughed workers unless, of course, your company chose to top up furlough pay. There is useful guidance published by the GEO to assist you in reporting. An update on immigration is that from the 1st of January 2021, as I'm sure you're aware, we are no longer part of the EU. In preparation for this, the government introduced the settlement scheme for EU migrant workers currently residing in the UK to gain either settled or pre-settled status. There is still time for EU migrant workers who were resident in the UK prior to the 31st of December 2020 and including this date to apply for either one of these statuses, and applications close on the 30th of June 2021. You are unable to request proof of EU settlement scheme status prior to this date, but you can, of course, always enter into conversations with your migrant workers, and if they choose to do so, they can provide you with this status. Our new points-based immigration system now applies and has done so since the 1st of January 2021, and you will need a sponsorship license to be able to sponsor EU and non-EU nationals in certain roles who do not currently have the right to work in the UK. If you need any assistance with this, please do not hesitate to contact one of our immigration team.
So there are many things that are coming up in the pipeline that were previously postponed or delayed due to the coronavirus pandemic. The Queen's speech in December 2019 announced that the government is planning a raft of new measures under a proposed employment bill, which would apply in the main to England, Wales and Scotland. The first of these are extending redundancy protection, and the government had previously announced prior to the Queen's speech in 2019 of its intention and proposal to extend the period of redundancy protection for pregnant employees, namely from the point that an employee notifies their employer of their pregnancy until 6 months after the end of their maternity leave. This amendment would also cover new parents returning from adoption leave and shared parental leave, and expands the entitlement to be offered a suitable alternative vacancy where one exists. Another update under the employment bill is neonatal leave and pay. This would be a new right providing up to 12 weeks paid leave for parents of babies requiring neonatal care. The consultation closed on the 11th of October 2019, although we still await the outcome to that consultation. In addition, there is a proposal to allow 1 week's unpaid leave per year, and this was a promise that was made in the Conservative Party's election manifesto. Again, we are still waiting an update as to when that would be introduced. As part of the Queen's speech, there was some discussion around the Good Work Plan proposals, which initially came out as a result of the Matthew Taylor review. One of these would be a measure to address one-sided flexibility, including a right for employees and workers to request a reasonable notice of work schedule with a potential penalty for non-compliance on the part of the employer. And in particular, this would be helpful for those on casual contracts, such as a 0 hours contract. There's also some discussion about a proposal for flexible working to be the default position and to encourage employers to be more transparent and flexible about working policies and parental leave and pay policies. This is especially more relevant now in light of the pandemic and changing working patterns. And there is an added expectation on both employees and employers to be flexible in terms of the employer's usual place and pattern of work. In addition, under the Good Work Plan, there is a proposal to require employers to pass on all tips and service charges to workers, to be supported potentially by a statutory code of practice, which would ensure that tips are distributed on a fair and transparent basis. And finally, under the Good Work proposals, there is discussion around whether it's suitable to have a single enforcement body for employees who are particularly vulnerable, to ensure that they can exercise their rights rather than having to choose which jurisdiction to pursue action through, whether that be the Employment Tribunal or the civil courts. There's also been quite a lot of awareness about domestic abuse, especially in light of the fact that there are many more people working from home now. And there was a consultation which closed in September 2020. In January of this year, the Department for Business, Enterprise, Innovation and Skills published a report into the measures that employers should be doing to support victims of domestic abuse. ACAS has also updated its guidance working from home during the coronavirus pandemic, and it includes a section on how to spot signs of abuse. In addition, I think the CIPD and the EHRC have also published a guide recommended that employers have a clear policy in place to support employees and a framework of support made up of namely 4 steps. Firstly, to recognise the problem, to respond appropriately, to provide support and make sure that there are channels within the workplace where employees can go to for help. There's another proposal in relation to family-related leave and pay. There's a consultation which closed on the 29th of November 2019 on a possible reform of family-related leave and pay, in particular considering increasing the amount of paternity leave, which is currently 2 weeks, and basically overhauling the pay structure and the types of leave available for employees. Linked to that, and also linked slightly to the increase in awareness for domestic violence, there was a consultation on sexual harassment in the workplace, which closed again in 2019, the outcome of which we're still awaiting. It was expected in spring last year, but because of the coronavirus pandemic, it's obviously been delayed. There is possible solutions include extending the 3-month time limit for bringing or workplace discrimination and harassment claims to 6 months rather than the 3 months. And consideration is also being given to extending protection to volunteers and interns, not just employees and workers. There is also, or has been, a consultation on misuse of non-disclosure agreements, or NDAs as they're commonly known. Again, this consultation closed in April of 2019, and in October 2019, the Women and Equality Select Committee confirmed that legislation would be introduced curbing the use of NDA provisions in contracts of employment and settlement agreements. We haven't actually seen the introduction of that legislation yet, but it is awaited this year. In light of the amount of time that employees are required to self-isolate and the number of people that are have been sick as a result of the pandemic, there is a consultation on reform of statutory sick pay. And whilst there aren't any current plans in place at the moment to change the rate or length of statutory sick pay, views have been invited as part of the consultation as to the impact that such changes could make on employees and employers, and whether it would, an increase in the length or the amount would have an impact on behaviours. There, as part of the consultation, a question was asked as to whether the payment of SSP should be enforced in the same way as payment of the national minimum wage as it is currently, and whether fines for non-payment of statutory sick pay, which is currently, I think it's a maximum of £3,000, should be increased, and that's still under consultation. Sorry, the consultation closed in October 2020, and we're still waiting a response on that. And finally, on this slide, there is, in a similar way to gender pay gap reporting, there is some discussion about whether or not there should be mandatory ethnicity pay reporting. And this consultation again closed early January 2019, and we are awaiting a response to that. But in January of 2020, a Labour peer had introduced a private member's bill, the Equal Pay Bill, which potentially would widen the scope of any pay gap reporting to beyond gender, to include pay gap between employees of different ethnic groups. And it would require the government to develop regulations setting out further details of how it would work, although it's not known whether the government will support the bill. But there are indications from businesses that are already capturing such data as part of their day-to-day gender pay gap reporting, and it's likely that this will be introduced, but we are still awaiting confirmation. And finally, you might have heard that there are some discussions as to whether or not post-termination non-compete clauses, or restrictive covenants as they're more commonly known, should be reformed. There was an ongoing consultation to this which closed in February of this year, and we are awaiting a government response, but it's essentially considering proposals for employers to pay compensation for the duration of the clause, or potentially having a statutory limit on the length of such clauses, or banning the use of them altogether. In Germany, I know that employers are required to pay employees for use of non-compete clauses, so it remains to be seen whether that will be introduced in the UK. And a similar consultation has been going on, which also closed at the end of February, regarding extending the ban on exclusivity clauses to cover those who are earning under the lower earnings limit, which is currently £120 a week.
We're now going to turn to the case law update. The first case that we're bringing to your attention is the case of UQ against Marklean Technologies, which deals with a redundancy situation. So the respondent, Marklean, dismissed an employee, UQ, on the 31st of May 2018. Between the 31st of May, the date that UQ was dismissed, and the 15th of August, a further 35 people ceased to be employed by the respondent. Although most of those other employees purportedly resigned, a Spanish court held that between 30 and 35 of them had in fact been dismissed for reasons of redundancy by the employer. And this meant that under Spanish law, the Spanish court could only look at dismissals predating UQ's dismissal when determining if it formed part of a collective redundancy. And the question that the Spanish court, referred to the ECJ was whether such a generally backward-looking approach, which contrasts to the UK approach, was compatible with EU law, and if not, what was the correct approach to take. The ECJ ruled that it is insufficient to consider only other dismissals either predating or postdating the date of a dismissal when determining whether it forms part of a collective redundancy. Instead, the reference period is the period of any 90 consecutive days during which the relevant dismissal occurred and in which the employer dismissed the greatest number of employees as being redundant. In effect, this suggests employers need to look at a rolling 90-day period and take into account dismissals already affected or underway when ascertaining whether they have reached the threshold at which collective redundancy consultation is required. The next case is the case of Higgs against Farmers School, which deals with protected characteristics. In 2018, Miss Higgs shared 2 posts via her private Facebook account, and these posts openly criticised the teaching of LGBTQ+ relationships and community at her son's primary school, and it encouraged other Facebook users to sign a petition against plans to make relationship education compulsory for young children. Following this, the head teacher of Farmers School, which is the school that Mrs. Higgs worked at, received an anonymous complaint which described the post as being homophobic and prejudiced to the LGBTQ+ community. Consequently, Ms. Higgs was suspended from her role at the school and an investigation was initiated. The investigation included a meeting between a representative from the school and Ms. Higgs, and Ms. Higgs alleged that she was questioned for 6 hours in an intimidating manner, and the Facebook posts that she had shared were compared to pro-Nazi views. Following the meeting, Ms. Higgs was dismissed from her role for gross misconduct. She then brought an ET claim for discrimination and harassment, arguing that her dismissal breached her freedom of speech and religion, and that due to her lack of belief in matters relating to gender fluidity and same-sex marriage, and her beliefs relating to when unbiblical ideas were promoted, that she should counter them. The ET dismissed her claim that there was a causal connection between her beliefs and the way she was treated by the school. The judgment, in fact, stated that their view was that her treatment was not because of the relevant beliefs, and accordingly her claim of direct discrimination failed. They also added that, although not stated as clearly or simply as this, the act of which we concluded Miss Higgs was accused and eventually found guilty was posting items on Facebook that might reasonably lead people who read her post to conclude that she was homophobic and transphobic. That behaviour, the school felt, had the potential for a negative impact in relation to various groups of people, namely pupils, parents, staff, and the wider community. The court also noted that Ms. Higgs made it clear that she had no intention of desisting from making any further such posts in the future. Ms Higgs' claim for harassment was also dismissed by the tribunal, with the judgment stating that this was an unexceptional disciplinary process. Whilst it clearly would have been unpleasant for Ms Higgs to experience it, we are not satisfied that the conduct had either the purpose or effect of violating her dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for her. We think this case gives some comfort to employers that they can take action against employees who express views on social media platforms which are discriminatory or cause offence to those with protected characteristics to guard the organisation's reputation. However, it will be important for any such action to be taken in accordance with the organisation's policies on equality and the use of social media, which should set out clear expectations for employees. The next case is Ryan v South West Ambulance Services NHS Trust. So in this situation, the claimant was in their mid-60s and the trust had a recruitment tool in place called the Talent Pool, which identified future leaders and managers within bands 1 to 7 and aimed to retain existing leaders and managers who were in band 8A, of which the claimant was one. The claimant brought a claim in the ET for indirect age discrimination, alleging that she was indirectly discriminated against when she was not able to apply for promotion on 2 separate occasions because she was not included within the respondent's talent pool. The ET originally found that the respondent had a provision criterion or practice of only promoting managerial staff who were in their talent pool, but found that there was no causal link between the PCP and the individual disadvantage suffered by the claimant because she had not realistically tried to gain entry to the talent pool. However, the ET, on appeal, the EAT agreed that there was a disadvantage to the group of which the claimant was one because of the PCP and the fact that she had not originally been included within the talent pool and had been prevented from applying for roles until the talent pool candidates had first been considered. The next case is the case of Heskett against the Secretary of State for Justice. The claimant was employed as a probation officer in Kent. In 2016, the claimant brought proceedings against the respondent for indirect age discrimination on the basis that the rate of pay progression for his job disproportionately disadvantaged younger employees, of which he was one. And the rate of pay had actually been reduced drastically as a result of austerity cuts that had occurred in earlier years, and this had slowed the rate of pay progression for younger employees. Previously, it would take a younger employee roughly 8 to 9 years to reach the top of their pay band. However, after the austerity cuts had been put in place, it would now take them a lot longer, up to 16 years in some cases. The claimant made reference to the cost plus principle, which provides that costs can only be relied on as an element in a justification argument which involves other factors. And the tribunal did focus on this point heavily, and they drew a distinction between cost cutting on the one hand and an absence of means on the other. It was the tribunal's view that the respondent was not only relying on cost cutting to justify the discriminatory conduct, but rather the absence of means created by the significant downturn in the economic climate, which forced the respondent to take action. The claimant appealed the tribunal's decision, and in fact the EAT's decision, who agreed with the first tribunal. And when it got to the Court of Appeal, the court considered at length the whole idea behind the cost plus principle. The court commented that if the reason was solely to avoid increased costs, the aim is illegitimate. Yet the court went on to say an employer's need to reduce its expenditure and specifically its staff costs in order to balance its books can constitute a legitimate aim for the purpose of a justification defence. With this in mind, the court concluded that the EAT was correct in upholding the distinction between cutting costs and an absence of means. In the claimant's case, the respondent was compelled to reduce its costs due to the financial and economic pressures, and the court concluded that this was indeed a legitimate aim. We then have the EAT case of Allais against Galen. The claimant was of Indian origin, and he was dismissed for performance-related reasons. He raised a complaint of harassment in relation to his race, which was investigated, and it was established that a colleague had made a racist comment towards him. Following the investigation, the colleague in question was provided with additional training. However, the claimant did bring a claim of harassment at the Employment Tribunal and was successful. The respondent then appealed this. However, both the first instance and the EAT found that the defence was not available, that the respondent could rely on the reasonable steps defence. And it wasn't available to them because the EAT found that the training had itself become stale. And this was because it had not been updated in over 20 months. So I think this just provides some guidance, following this case, that employers should expect tribunals to scrutinise the contents of policies and trainings much more closely in the future in order to assess their quality and effectiveness.
Quilter Private Client Advisors Limited and Falconer and another was a High Court decision concerning post-termination restrictions. The individual concerned was a financial advisor for Quilter, and after 6 months of working for Quilter and within her probation period, she gave notice of resignation. She was put on garden leave for the remaining 2 weeks of her employment, and shortly after started a new job with Continuum, which is also a financial advisory business. The individual's employment contract with Quilter included a 9-month non-compete restriction, a 12-month non-solicitation covenant, and a 12-month no-dealing covenant. The restrictions did not prevent the employee from being engaged or concerned in any business that was not in competition with the services offered by Quilter, or in services or activities that the individual was not concerned with to a material extent in the 12 months before termination. The court considered it likely on the facts provided that she had knowledge of the restrictions and had also accepted them. As a result of the individual obtaining new employment in a competing business almost immediately after termination, Quilter brought a breach of contract claim against the individual and the new employer Continuum and sought to enforce the restrictions. In a very detailed discussion on whether the restrictive covenants were valid, the court considered if the covenants had been shown on the evidence by Quilter to be no wider than is reasonably necessary for the protection of its legitimate business interests, and overall decided that they were not. The tribunal considered that the individual was subject to a 6-month probationary period, meaning that it was envisaged that she could have been dismissed at any point during that period and still would have been subject to a 9-month non-compete restriction. Quilter was not able to satisfy the court that there was a legitimate business interest behind that decision. In comparison, the head of Quilter was only subject to covenants lasting for 6 months and had access to far more confidential information than the individual in question. The individual's employment contract did appear to be a one-size-fits-all contract and used for generally more senior employees than she was, and there was insufficient thought given to the suitability of the restrictive covenants for an employee of her status. It was further discussed by the tribunal that the individual, or by the court rather, that the individual had only been with Quilter for 6 months and had therefore not had time to build established relationships with clients. Again, Quilter were unable to justify such lengthy restrictions on her post-termination when she had been there for only a short amount of time. Each of the restrictive covenants were found to be unjustified and void. So the key takeaway from this case is a reminder to consider the reasonableness of your restrictions in different scenarios and to tailor them as needed. For example, consider applying shorter and more limited covenants for an initial period, particularly during a probationary period. And do not be tempted to use a blanket approach to restrictive covenants, and consider if you would be able to justify each of them should you need to have to rely on them. Gordon and J&D Pierce was an appeal to the Employment Appeal Tribunal regarding a constructive dismissal claim. The claimant's claim had been that the employment relationship had deteriorated so much that there had been a breach of the implied term of trust and confidence, which is a fundamental term of the contract, and which had entitled him to resign in response. The claim failed partly because the ET did not agree that there had been a repudiatory breach of the contract and that both parties had contributed to the breakdown in the employment relationship. Additionally, the tribunal had found that even if there had been a fundamental breach of contract, the claimant had affirmed the contract of employment by engaging in the respondent's grievance procedure. By taking steps to affirm the contract, it was held by the first instance tribunal that the claimant had forfeited his right to rely on the breach of the implied term of trust and confidence, and that therefore the contract continued. The appeal tribunal did not agree that the claimant had affirmed the contract and noted that exercising a right of grievance, or perhaps in some cases an appeal, if it's, for example, a disciplinary matter, should not be regarded as an affirmation of the contract as a whole. Grievance or appeal provisions may be regarded as severable from the remainder of the contract and can survive the contract independently. As he was not deemed to have affirmed the contract, if there had been a repudiatory breach of contract, the claimant would therefore have been entitled to resign in response to that breach. So the key learning point from this case is to keep in mind that just because an employee may continue with an internal process following their resignation, this will not prevent them from bringing a constructive dismissal claim in the tribunal. Chalmers and Airpoint Limited is another appeal tribunal claim for constructive dismissal and discrimination on the grounds of sex. Ms. Chalmers worked as a business support manager carrying out HR functions for the respondent. She was one of only 2 female employees for the business. The claimant's claim arose as a result of the staff Christmas party. All employees were invited, but neither the claimant nor the other female employee were able to attend. The party went ahead as planned anyway. The claimant emailed her employer to initiate a grievance with a number of complaints, which included that she was unhappy she had been excluded from the Christmas party and stated that this may be discriminatory. Her grievance was not upheld by the employer, and so she brought claims of harassment and victimisation to the ET on the grounds of her sex. In reference to the victimisation claim, the claimant relied on the emailed grievance being a protected act as a complaint that referred to discrimination on the grounds of sex. The tribunal and the appeal tribunal discussed this in detail and whether the words may be discriminatory amounted to an actual complaint of discrimination or not. The tribunal considered that the word may, in its natural meaning, might usually be thought to signify doubt or uncertainty, and therefore the grievance did not allege that she had actually been discriminated against on the grounds of sex and was therefore not a protected act. The tribunal also took into consideration that the claimant had HR experience and knowledge and therefore was informed enough to take a view as to whether her non-invitation to the Christmas party was an act of discrimination on the grounds of sex at all. As such, the failure to assert that there had been sex discrimination in her grievance undermined her submission that she had made an explicit allegation of sex discrimination. The tribunal also considered that the claimant was articulate and well-educated, and therefore it was unlikely that she had mistakenly used the word may or missed out the word sex to describe the form of discrimination. Having taken all those circumstances into consideration, the appeal tribunal found that the tribunal was entitled to come to their conclusion that the grievance had not been a protected act, and as a result, the claimant's claim for victimisation failed. A key learning point from this case is to note that employers are entitled to consider all of the circumstances when deciding whether a complaint of discrimination has been made and should be acted upon. It should not be assumed that any complaint mentioning discrimination will automatically amount to a protected act under the Equality Act. Shell and Tarmac Cement and Lime Limited was appealed to the High Court, amongst other things concerned the issue of vicarious liability. In this case, the claimant was a site fitter whose services had been contracted out by a company called Rolltech to the respondent at one of its quarry sites. There were tensions between the Rolltech employees and the respondent's employees, and it was considered that the respondent's employees perhaps considered their jobs to be under threat by the Rolltech contractors. The claimant had made the supervisor aware at the time of the issues between the 2 sets of employees. These tensions came to a rather explosive finish when one of the respondent's employees sought to play a practical joke on the claimant by placing a pellet target on a bench close to the claimant's ear. He then hit it with a hammer and caused such a loud explosion that this caused the claimant to have a perforated eardrum, hearing loss, and tinnitus. The responsible employee was duly dismissed by the respondent. But the claimant then brought a claim against the respondent alleging negligence and being vicariously liable for the practical joker's actions. The court worked through the legal test for vicarious liability and agreed that there had been a clearly close relationship between the employee and employer, as clearly demonstrated by a contract of employment being in place. However, in considering whether the act itself was sufficiently related to his employment relationship, the employee had brought his own pellet to work. It was not something that had been provided by the employer. He had used the workplace as simply a convenient location to enact the practical joke. The act was unconnected with any instruction he had been given by his employer, and it was not something that could possibly have been within the field of activities that had been assigned to him by his employer. In other words, to refer to that well-used phrase, he was considered to be somewhat on a frolic of his own. Although the claimant had made the respondent aware of the growing tensions, the threats of violence and injury had not been contemplated at that time and had not been communicated as so serious that the threat could have been suggested either. As such, the respondent could not have foreseen a risk of injury to the claimant and was therefore not liable for the actions of the employee. The key points to take from this is to be vigilant about workplace issues and, particularly if there are signs of horseplay, ill discipline or malice, consider whether any additional steps are required to avoid vicarious liability for any wrongdoing. That brings us to the end of our employment law update, so thank you for listening.